Welcome to the Whitehill Financial YouTube channel. We're joined here with estate planning attorney Aaron Roepke to unpack the significant changes in the Washington estate planning law that came into effect July 2025. If you're a business owner or a high net worth individual in the state of Washington, this episode is for you. Let's dive into how these changes can impact your legacy and what you can do to prepare for that. So, Aaron, in this new estate tax law changes, can you explain the recent changes and what went into effect in July of 2025?
Yeah, so this is all very recent change to the Washington estate tax. For the last several years, that tax has remained fairly stable, and individuals each had an exemption amount of $2.193 million. And that exemption represents the value of assets or the amount of assets that could transfer upon somebody's passing under their estate plan without having to pay Washington estate tax. One of the significant changes to this new 2025 update is that individual exemption amount is being increased. So it's raising from $2.193 million per person to $3 million per person. And the other significant thing is that for probably the last 5-7 years, that exemption amount has remained a fixed amount. $2.193 million has remained the exemption amount for quite some time, and it's not been adjusted for inflation or cost of living adjustments. So another significant update is that $3 million exemption amount will be adjusted annually for those inflation and cost of living adjustments. So that's a positive thing for most folks. We have an increased exemption amount, and that allows individuals to transfer more to their intended beneficiaries without having to pay tax on the exemption amount. Now, on the other side, we also saw an increase to the taxable rate, especially at the higher levels. So an important thing to understand about the Washington estate tax is that it's a graduated tax scheme. So it's not a fixed tax rate. There's going to be different rates that apply on how far over the exemption amount you are. For example, if you have an estate that's worth $7 million for a married couple, and we utilize the individual exemption amounts of each spouse and are able to transfer $6 million tax-free under the exemption amount, and there's $1 million subject to the tax, that's going to be subject to a 10% rate. But that rate will go up depending on how far over the exemption amount you are. So at the highest level for estates exceeding the exemption amount by $9 million, our highest taxable rate is a 35% rate. And that's changed significantly. That's a significant increase in the tax rates. So it's a fairly steep tax. And for folks that are quite a bit above the exemption amount, for larger net worth individuals, it's advisable to do some tax planning to really take the sting out of that tax. So those are the main things. For most folks, that increased exemption amount is good news. For higher net worth folks, the tax rates have gone up significantly. For estates that are significantly over that exemption amount, that's bad news.
Okay. So,
Thank you.
Categories.
So when we kind of look at that, then with that increase from 2.193 million to 3 million, how do you see that impacting most Washington residents?
I think for most folks, that's good news. Most of the folks that I work with in this area, I'm in Moscow, Idaho, and work with folks in Idaho, Washington. But a lot of folks are sitting with the states that are within that exemption amount. We had a client that with the lower exemption amount, they may have had estates that were over the exemption amount. But for most folks, a $6 million exemption gives some breathing room, especially if we're able to plan for a married couple. When I say $6 million, I'm talking about a married couple with spouses each utilizing their individual $3 million exemption. I think for most folks, that's a good thing. And it gives us the ability to transfer more to intended beneficiaries, whether it's children or otherwise, without having to worry about that tax.
Right.
There are obviously people that it's going to hit harder, right? And so those higher net worth individuals, Washington residents subject to the tax with higher net worth that are significantly above that amount, it's bad news.
And that's because of
Gotcha.
those new estate or those new tax rates that have gone in that you were talking about.
Those tax rates, it's a steep rate. A 35% tax is a steep rate. And we also are looking at this through the lens of a state tax. And we haven't even talked about federal estate tax considerations for higher net worth individuals that are subject both to Washington state estate tax, federal estate tax. Without planning, they could effectively be looking at a combined rate of 61%. I mean, that's a bite out of the apple. That's a steep tax.
Yeah. With that top marginal estate tax increasing to 35%, what are some strategies that individuals could consider to mitigate the potential tax liabilities? So now talking to those higher net worth clients who would potentially be exposed to that.
Yeah, so I think starting from basics, and this would be applicable across the board. I mean, I would give this advice to anybody, even if they're under the exemption amounts to higher net worth. You know, you want to start with a solid foundation and good practices across the board. And so I think for a married couple, we want to make sure that your plan is utilizing the ability to use the exemption amounts of each spouse. And in order to do that, we have to plan for that within your estate plan. So every individual has their individual exemption, $3 million. And so that would be true of spouses, husband, wife, they each have their individual $3 million exemption amount. For a typical plan between a married couple, there's usually a provision that says if I pass and I'm survived by my spouse, then I leave assets to my surviving spouse. So there's a transfer first to the surviving spouse upon the death of the first. Now understand that transfer from one spouse to the other is a non-taxable transfer. So there was no need to use the exemption amount for that transfer from the first spouse to pass to the survivor. But the thing that you have to take into consideration regarding the exemption is that it's a use it or lose it exemption. So if there's a transfer to a spouse and that's a non-taxable transfer, then that exemption is gone at that point. And it can't then be used by the survivor upon the surviving spouse's passing. So that leaves us upon the passing of the survivor spouse. Maybe there's provisions to transfer assets equally between children at the death of the second spouse. That transfer is going to be taxable. And in this circumstance, we only have the exemption amount of the second spouse to work with. So we've got a $3 million exemption to work with. What we want to make sure that we are doing preserving that unused exemption of the first spouse to pass for use by the survivor after both have passed. And we do that through a tool called a disclaimer trust. And this is a credit shelter trust. Instead of transferring assets to a spouse upon the death of the first, there's a transfer to a specific type of trust. And this trust allows us to shelter that unused exemption so that it can then be used by the second spouse to pass in addition to their own individual exemption amount. So in effect, we have both exemptions to use at that time. And that would be our primary tool and our foundation for Washington estate tax planning for a married couple. We want to make sure across the board that we're doing that.
Gotcha. Great. Thank you. And you had touched a little bit on it earlier, and I want to take us back into this topic a little bit. But how do these state level changes interact with the federal estate laws? You know, especially considering the federal tax exemption is much higher. So you kind of mentioned that, you know, somebody could be looking at 61% going to combined governments. Can you touch a little bit on that?
So you have to be, it's easy to confuse all of these different types of taxes. And these taxes are unique and most folks aren't accustomed to dealing with them. We're familiar with income tax or we're familiar with capital gains tax if we've sold an appreciated asset. But inheritance tax, it's not something you're dealing with during life. It's a tax that your estate is liable for after you have passed. And so a lot of people are unfamiliar with this concept. And it's just like income tax, where you have both state and federal taxes, right? And it's the same thing here, where we have a state inheritance tax. And not every state has an inheritance tax, but Washington state is the state that does. And then we also have this federal estate tax. And the federal estate tax is tied fairly closely with federal gift tax. But again, there's federal gift and estate tax exemption amount, and this is a lifetime exemption amount, and that represents the amount of assets that you can gift in life or gift or transfer upon your death without having to pay tax on that transfer. And that in 2018, that exemption amount was raised to $10 million per person, which gets adjusted for cost of living and inflation. And so for 2025, it's just north of $14 million per person. With the passage of the big, beautiful bill, that's going to change. So 2026, it's going to change that federal estate tax exemption to $15 million per person. Again, that's going to get adjusted for inflation and cost of living adjustment. So that's significant. And that, again, that's an individual exemption amount. The other nice thing about federal law is that federal law includes something called a portability provision. So without having to go through the process of setting up this credit shelter trust, for a married couple, we can make a tax election on an estate tax return, or we can port an unused exemption first spouse who's passed to the surviving spouse, and that's a very easy mechanism for preserving that exemption for use by the second spouse to pass after both have passed. So in effect, for federal estate tax purposes for a married couple, there's a $30 million cushion to work with for both gift and estate tax. Those exemption amounts are much bigger on the federal level. But for those high net worth individuals that exceed that, if we have a married couple with net worth exceeding 30 million, it's above the Washington exemption amount a lot. It's going to put them in that 35% taxable rate category. It also puts them in the territory of federal estate tax. And so now we've got two separate estate taxes are being assessed against the same estate, the same assets. And there are deductions against the federal estate tax for payment of state estate taxes, but it's still a steep tax. And that federal estate tax rate is a 40% tax. So again, that's a steep tax.
Yeah, that's spicy. And not really shifting too much, but shifting slightly here. Since we cover such a broad range of Washington state, with Dave knocking on Idaho's door as you're in Idaho, if we had a client who owned property in both Washington and Idaho, given the differences between the two states, how would owning property in the two states affect them?
Well, I think it would be worth giving serious consideration to making Idaho your state of domicile. And understand there's differences between domicile and residence, your state of residence, and you can have more than one state of residence. And this is common for a lot of folks that have a home in Washington and then maybe a vacation property in Idaho, or they may have a winter property, a snowbird situation where somebody owns property in Florida or Arizona. So it's fairly common for people to have property that's located in different states, and they may have several states of residence. But you can only have one state of domicile. And so if you're domiciled in Washington, you're going to be subject to this Washington inheritance tax. If you're domiciled in Idaho, Idaho is a state without an estate tax. And this is common where I practiced in Moscow, right on the Idaho-Washington line. I think it's worth a serious conversation, and serious consideration should be given to changing your state of domicile to Idaho as a way to not be subject to that state estate tax. And then for the Washington property, the Washington Department of Revenue has taken the stance that a business entity like a limited liability company and personal property and jurisdiction over that property will be subject to your state of domicile. So if your state of domicile is Idaho and you set up an Idaho limited liability company that owns your Washington state property, we've just converted that into personal property that's subject to the jurisdiction of the state of Idaho. And that's a common way to plan for avoiding being subject to this state level estate tax.
Gotcha. Great. Thanks.
Great. Kind of shifting gears kind of more to the business owner side. What should business owners be aware of regarding the new estate tax law in Washington?
So there are some deductions. Just like any tax, there's exemptions and there are deductions. So there's assets that we can deduct. So we can have them treated so that they're not considered part of your taxable estate. So if we're adding up the assets that are subject to the tax, there's going to be assets we would put in this taxable category and assets that we put in a non-taxable category or an exempt category. We can deduct those assets from the tax. And I think for a family business, so thinking about a closely held family business, there is a deduction. It's called the QFOBI deduction, the Qualified Family-Owned Business Interest Deduction. And that allows us to deduct the value to a certain amount from a person's taxable estate. So with this deduction, if we qualify for it, say that there's a family-held limited liability company, the family-owned business, maybe it's a husband and wife-owned LLC. The family business is being done through this company. If we plan appropriately for the transfer of this business, so there are some pretty strict rules required in order to take advantage of that. You have to leave it to a qualified heir, a child, a bloodline descendant. You have to be materially participating in the management of that business within a certain time period from your date of death. And then your qualified heir has to continue to own and run that business within a certain time after your passing. If we're able to take advantage of that deduction, we can deduct the value of that business from your taxable estate. So it gives us a way to transfer a closely held family business to qualified heirs, family members, as a non-taxable transfer.
Just a real quick question that kind of popped up into my head. Do the heirs have to be working in the business prior to the date of death, or do they just have to be working in it after to qualify for that?
Well, I think there's a conversation to be had about that. Most folks don't want to be tied to the family business and work in it until they pass. Want to retire. So it has to be, there's this material participation requirement that has to be met, but it doesn't necessarily have to be met by the person who's passed. It has to be material participation by the person who's passed or by a family member. It's part of a larger conversation about business succession planning, especially for a family-held business, keeping it in the family. We need to have a family member step in to manage it, maybe while parents have retired, and then continuing to manage that business after parents have passed. If they do that within certain time frames and time parameters, we can qualify for the deduction.
Perfect.
There's a similar one for the owner of a farm. It's a separate deduction. There's a farm ground deduction, but it operates in a very similar fashion as this qualified family-owned business interest deduction, where we can deduct the value of farm ground or equipment or machinery of the value of somebody's taxable estate. For me, practicing here in Moscow-Pullman, Whitman County, Latah County, these are agricultural counties. And taking advantage of this exemption is a huge one. For a lot of folks in Whitman County, if their estate value exceeds the exemption amount, it's because they own farm ground, and the value of that farm ground is going to bump them above the exemption amount. It's a valuable asset. So planning to take advantage of the farm deduction for Washington estate tax purposes is an important thing because we can deduct that value. And then hopefully looking at other assets, the exemption amounts are enough to transfer the remaining assets tax-free once we've deducted out the value of the farm property.
So,
Great.
thank you.
So something you said about the transfer of business and the family members participating in the business prior to death. What happens if the owner of a closely held family business passes away unexpectedly? Do those deductions or transitioning the business to a family member, so keeping it in the family, keeping it closely held, how would that apply?
Well, it kind of emphasizes, your question emphasizes the importance of estate planning, and it emphasizes what I think people find intimidating and scary about estate planning is that that's the big variable in all of this. We're putting together these complicated plans tied to how we're going to transfer assets around somebody's passing. And we don't know when that's going to happen. And we can't anticipate the circumstances in which it's going to happen. It's hard to confront them. It's just that uncertain. If, as a financial planner, you guys want to eliminate variables. You don't want there to be unknown variables or factors that could affect your plan one way or another. But here we're working around a very unknown variable. So I think that emphasizes just planning early and also understanding that estate planning isn't necessarily a one and done process. Your plan evolves as your life evolves and as your assets evolve, especially for a family business. I mean, there's lots of different ways that business can grow and develop. And oftentimes that growth and development may be in completely unexpected ways, in terms of value or services or goods that are being provided, or, for somebody that starts a business at the same time they're starting their family, do they know that their children are going to want to work in that business when they get older? I mean, all of that's unknown, and that's going to change over time. And so your plan will change. It's going to change as your children grow older. It's going to change depending on which way your business grows or which direction you want to go with business. And so I think as a way of dealing with that, it's just pointing to how your plan should evolve along with your life. And that means visiting it periodically. I'm trying to be grim here where I'm recommending contemplating mortality as a practice or habit, but just being responsible about your plan, right? And if there's a change in your business or children are growing and you see one of them taking an active interest in the family business, and where we see things go south is where people don't plan, they just haven't done it at all. Or they've planned for a family business and we have other family members that are involved in that business, but there weren't any conversations about the plan. And so people's expectations are completely changed or altered once they find out the details. So just understanding the nature of the business and the people participating in it and kind of the team aspect of that business, there's a lot of intentional communicating that should go on in order to effectively execute and implement that plan.
Sure. Could you talk a little bit about some of the estate planning tools like gifting strategies, family limited partnerships, or irrevocable life insurance trusts that can help minimize the estate tax while retaining control of that business?
Yeah. So we see this, we've talked about the different taxes in terms of estate tax, whether it's a state level tax or whether it's federal estate taxes. And we've talked about the exemption amounts. And so we may see somebody that's got an estate that's right at one of the exemption amounts. So let's say we're planning for Washington state taxes in 2026. We've $3 million exemption amounts per spouse, and we've got husband and wife that have a family-owned business together. And they're hovering right around $6 million. Now, what we're worried about is we're assuming there's going to be future appreciation of assets. And as assets appreciate, we're going to get into this taxable estate, right? We're going to have an estate that exceeds our exemption amount. And so as a potential planning tool, depending on the assets of the estates, there's one of the assets is life insurance. I think some low hanging fruit in this scenario is to make use of something called an irrevocable life insurance trust. And again, this is a trust, specific type of trust that's meant to hold a life insurance policy, gives us an opportunity to treat the policy held within the trust as a non-taxable asset. So it removes the cash value of that policy from somebody's taxable estate by using this irrevocable life insurance trust. So that, I think, for anybody that's nearing or approaching this taxable estate level, whether it's state or federal, I think if there's life insurance involved, making sure that we set up an irrevocable life insurance trust would be just standard practice. That's an easy thing for us to use to take the life insurance out of the taxable estate. There are also gifting strategies. So we talked about federal gift and estate tax, the federal gift tax. There are 2 exemptions that we could potentially use. So there's an annual exemption, which represents the amount that you can gift annually without having to report it to the IRS. And that's $19,000 per person. So a married couple could they each have that exemption. They could each gift a child $19,000 a piece to kind of curtail inflation in an investment, or maybe inflation within a business or whatever the asset may be. For somebody that's subject to Washington estate tax, but they still have a cushion under the federal gift and estate tax, they may consider a larger gift. You can do that by gifting within an LLC. You could gift a membership interest in that LLC to children. So let's say husband and wife are going to retain a controlling interest. They're going to retain 51% of the interest together so that they can control, but they're gifting at once or over time interest in that company to kids. That represents a slow onboarding process where you're giving children, you're vesting ownership in children over time. They're acquiring ownership and responsibility and a vote within that company over time instead of inheriting it after somebody's passed. Those are strategies to take advantage of some gift tax and the estate from appreciating in value above the exemption amount. But those are usually tools for people that are hovering right around the exemption amount and they're concerned about future appreciation and value, lifting them into this taxable estate.
Got it. Thank you. Since we're talking about specific strategies, what estate planning documents, agreements, etc., should a business owner or otherwise have in place to ensure the continuity of the estate number one, for incapacity, right? Not just death, but incapacity as well as passing away.
Yeah. So powers of attorney, if we're addressing incapacitation, powers of attorney are going to be the standards, easiest way for anybody to plan for possible. Conceptually very simple. It's a document where you're naming an agent and you're giving your agent power and permission to make decisions on your behalf in the event you're incapacitated. Typically, there's a power of attorney for finances where you're appointing an agent and giving them authority to make financial decisions on your behalf, again, in the event you're incapacitated. And then there's a healthcare power of attorney where a person's doing the same thing for healthcare decision. Those are important. They're simple documents. The most important part about those is choosing your agent. Big responsibility. It's an important choice. I think that you should take that seriously. And then in terms of planning for transition of assets upon your passing, there's different ways to do this depending on your circumstances and your personal goals. I think would inform which is better. I don't think there's a one size fits all process for this. We either do it through a last will and testament. Think of that in simple terms. It just represents a set of instructions on who you want to inherit assets. You pass. So we can use a last will and testament, or we can use a revocable living trust. And it's doing the same thing. It's acting as a will substitute, where again, you have specific instructions on who's going to inherit assets upon your passing. So they're both getting you to the same result. The way that happens is different between the two. So one or the other, depending on your preferences, your will has to go through a process legally called probate. And for some people, that's not a big concern. Other people, avoiding probate is a big concern. That's where we would look at the revocable trust. At its core, for anybody, whether you're high net worth, whether you're a business owner, whether you've got simple assets in your estate, whether you've got complex assets in your estate, those would be the core of the estate, where you've powers of attorney and a will or living trust.
And I know as a small business owner, Dave and I, we have buy-sell agreements, right, for our business should something happen to either one of us. What is imperative for if you're operating on a partnership level or in a multi-owner situation of a business? What is imperative to be included in that buy-sell agreement?
Yeah, so I think first and foremost, partners in that business have to communicate about this. And you've got to think about future ongoing practice of the business after the death or exit of a partner. And understand, so let's just say that Lisa and David, you own your company, you're 50-50 owners, your 50% ownership in that company is an asset, and you're free to do what you want with your own asset, right? So if you wanted to gift that to somebody, you can. If you wanted to leave it to somebody under your will or trust, you can. If you wanted to encumber it, so let's say one of you wanted to take out a personal loan and the bank asks, well, what can you put down as collateral for this loan? You say, well, I own half of this business. I'd like to use. So those are all options, but understanding, because you're partners in a business, in a joint venture, you probably want to restrict some of it so that there's not complete freedom. So David, let's say I approach you and say, hey, I know you own 50% of this company. I would like to buy them. Lisa wants to say and who she winds up business partners with, and she may or may not want to be business partners with me. So that's the point of these buy-sell provisions, is to control and basically give the partners the option to pay each other out in the event of transfer, unless it's to a defined group of people that you've agreed on. We can transfer to these folks. In your case, that may or may not be the case. That all needs to be spelled out in a buy-sell agreement. So we've got to define the scenarios where there's going to be a buyout. If there's going to be a buyout of a business partner upon their exit, whether it's because they pass or retire or try to sell, we've got to define what that buyout is going to look like. How is the interest be valued? Valuation concerns are a big thing. What will payment of that buyout look like? Do you want to define what that will look like? Do you want to try to negotiate the buyout terms? There should be some default terms in case partners can't agree. And there should be a valuation formula in case partners can't agree. And this can happen in good circumstances where there's an exit of a partner. It could happen in sad circumstances, a partner passes, or it could happen in adversarial circumstances where there's conflict between partners and you're not able to agree. So that's the purpose of this buy-sell agreement, is to define these things while you're like-minded, while you're on the same page, while you're both communicating about it, so that we can define the terms of this potential buyout upon exit of a partner. Now, in the small family business scenario, that could be important. Let's take a family farm, for example, it's in an LLC, and this is farm that's been in the family for multiple generations. And it's the intent of the family to keep that property within the family bloodline. So again, buyout provisions would be important here, and we can define bloodline descendant as somebody who can come in as an owner of the company. But we have buyout provisions if there's transfer to somebody that's outside the line. So that's a way for us to try to keep interest within the family blood.
Great. We really appreciate that, all of that in exploring the new tax laws and estate planning when it comes to Washington State. This wraps up our part 1 of our estate planning deep dive with Aaron. We've covered some big changes in the law, key risks for business owners, and where to begin with proactive planning. Be sure to catch part 2, where we go beyond the taxes and into the building blocks of a solid estate plan. Thanks for catching us, and remember, it's never too early to build a plan for the future.